be covering some practice questions based upon the portions of the rules that we've already covered in the course so far. Let's turn to question 1. The facts tell us that an attorney represented a defendant in a civil case. The defendant was being sued after allegedly running a red light and striking the plaintiff's vehicle. The defendant testified at trial that the light was a green when the defendant drove through it. The defendant's testimony was consistent with the story that the defendant had told the attorney in the past. However, the attorney was trained in detecting when someone was getting nervous or lying and did not personally believe the defendant's story. There was no other evidence that the defendant was lying and that the defendant's story was consistent with the story of nearby bystanders. The jury found in favor of plaintiff. Is the attorney subject to discipline? So again, trying to always start by articulating the rule that's being tested so that we can try to reach a conclusion on our own. Here, the rule that is being tested is that if a lawyer or a lawyer's client or a witness that's been called by the lawyer has offered material evidence and the lawyer comes to know of its falsity, that lawyer must take reasonable remedial measures, including, if necessary, disclosure to the tribunal. So in other words, if a lawyer calls someone up to the stand as a witness and that witness offers material evidence or testimony and the lawyer comes to know that that information is in fact false, the lawyer has to take steps to remedy that. Here we're told that the lawyer called a client up to the stand, let the client kind of tell his or her version of the story that occurred. The lawyer didn't really buy it, but the lawyer doesn't know whether or not it's true or false. So here what's key, and this is why it's so important to have the rules memorized, is that the rule is triggered by a knowledge requirement. Specifically, the rule says if the lawyer, a lawyer's client, or a witness called by the lawyer has offered material evidence and the lawyer comes to know of its falsity, then the lawyer must take those reasonable remedial measures. Here, this lawyer doesn't know if the information provided is false. The lawyer has an idea, but again, can't point to anything that says, yes, this is in fact false. So because of that, the lawyer isn't under any sort of obligation to reveal his or her feelings to the court about what he or she thinks about this testimony. In other words, the rule isn't triggered. So the call to question asks, is the attorney subject to discipline? The answer would have to be a no answer because, again, the rule requires a knowledge requirement and the lawyer in question doesn't know if the information provided was false. So let's see if any of our answer choices match with that. A says yes, because the attorney called the defendant as a witness, even though the attorney thought the defendant was lying. So A is wrong because calling someone to the stand, not knowing whether or not they're lying, isn't prohibited by the rule. The rule prohibits the lawyer standing next to evidence they know is in fact false. So A misstates the rule or the obligations here. B says yes, because the attorney failed to take reasonable remedial action after he detected the defendant was lying in court. So B is a good trap answer if you didn't know the rule. Here the rule requires knowledge. The lawyer doesn't have knowledge of a lie, so B is wrong. C says no, because the jury apparently disbelieved the defendant's testimony. Be on the lookout for answer choices like C. It's kind of like a no harm, no foul like choice. Here they're essentially saying it doesn't matter whether or not the defendant lied because the defendant didn't win. And that's not the point. If the lawyer had committed a rule violation, it doesn't matter what the jury thought. The lawyer would be under an obligation to act. So C is wrong. And D says no because the attorney did not know of its falsity. Well, this is exactly what we're looking for because the rule requires knowledge. So D is the correct answer. Turning to question 2. One of the attorney's regular clients, who was a longtime personal friend of the attorney, was traveling to another country to compete in a competitive sport. Prior to leaving the country, the client paid the attorney a retainer of $100,000 so that the attorney could pay the client's insurance bills when they became due. the insurance bills ended up totaling only $80,000. The attorney needed to pay off a personal debt of his own in a short period of time and borrowed $10,000 from the client's trust account. The attorney did not ask the client's permission to do so since the client was out of the country. However, the attorney thought that the client would approve. A week later, the attorney settled a large case of his own and deposited $10,000 back into the client's trust account. Further, the attorney paid 8% interest on $10,000 and deposited the interest in the trust account as well. 8% is higher than the standard interest rate, so in the end, the client benefited from this transaction. When the client returned from the trip, the attorney told the client what he had done, and the client approved of the conduct. Is the attorney subject to discipline? Okay, so the rule being tested here is about clients' property or funds and the management of it. Specifically, the rules tell us that we are supposed to keep our clients' money, their property, separate from our own, and we're never supposed to use clients' money or property for our own personal use. Here, clearly, the lawyer did just that, and that's a problem. It doesn't matter that the lawyer eventually got permission. It doesn't matter that he paid extra interest on this loan. What matters is that he used the client's money as his own, and he did all of that without permission. So this is a problem. So the call to question asks, is the attorney subject to discipline? So I'm going to be looking for a yes answer that states something along the lines that lawyers are supposed to keep client property separate from their own and are never supposed to use it for their own personal use. So let's take it from the top and evaluate each choice provided. A says no, so long as the attorney's conduct did not amount to commingling of funds. And A is wrong because there is a problem with what the lawyer did. The lawyer used the client's money as his own, and this is essentially like commingling because the lawyer dipped into the client's account and took the money for his own personal use. B says no because the attorney reasonably believed at the time she withdrew the money that the client would not object given their long-standing personal friendship. So B is problematic because it's basically saying there's an exception, maybe if a lawyer knows the client, and that's not the case. The rules make it abundantly clear that lawyers are not supposed to be using client funds or property as their own. So B is wrong. C says no because the client was fully informed of the attorney's actions and consented to the actions, thereby retroactively ratifying the attorney's conduct. So there is no such thing as retroactive ratification here. That's not a thing. What happened here is the lawyer violated the rule by taking the client's funds and using them as his own, and then later told the client about it. That's not okay. There is no such thing as that retroactive ratification. So C is wrong. Answer choice D says yes because the attorney used the client's funds for a personal use. And this is exactly right. In fact, it uses the language of the rule, and it's exactly what we've been saying the whole time. So D is the best answer. Turning to 3. The facts here state, the following advertisement appeared in an online advertisement in a state in which both attorneys are members of the bar. Attorney Alan Abel, JD, and attorney Betty Buttons, JD, attorneys at law, ABCDE Street, State 99999, their telephone number, and then we have never lost a trial. Both attorneys are new and have never tried a case. Are the attorneys subject to discipline? Okay, so the rule that's being tested by this fact pattern is all about lawyers or attorneys advertising of their services. And more specifically, the rule's pretty clear here. The rule says that a lawyer shall not make false or misleading communications about themselves or their services. And it goes on to tell us that communications are false or misleading if it contains a material misrepresentation of fact or law, or if it omits a fact that's necessary to make a statement considered as a whole not misleading. So in other words, you can have ads, for instance, that violate these rules if what the ad says is technically true, but if it doesn't provide all of the information that is necessary to the client or to the person reading it to understand what it's saying. So here, what it's telling us in the fact pattern is you have this ad for two brand new lawyers who are licensed to practice law, who have never had a case, and yet their advertisement says we've never lost a trial. So while technically they haven't ever lost a trial, they've never had a trial. So this is a specific instance where omitting a fact is problematic, because if you knew as a consumer that they've never lost a trial, but they've never had a trial, that would mean something to you. It would mean a lot more than just saying they've never lost a trial, right? Because without the fact that they've never had a trial makes you believe that they're just so good at what they do, they've never lost. And that's not the case. They've never had a case to take to trial. So this is problematic, and it does violate the rules. So let's look at our call to question again. It states that, it asks, are the attorneys subject to discipline? And we would be looking for an answer that says yes, because while this ad is technically true, it's misleading. So answer choice A says no, because both attorneys are permitted to make statements that are truthful and not misleading. Okay, so A is a good rendition of the rule, except it's not being applied properly. While these statements are truthful, they are misleading. So A is wrong. B says no, because all the statements are true. Well, the statements being true is just half the rule, right? So B misses the point there. C says yes, because their advertisement's misleading. Well, this looks good. We know that while the statements are true, this is misleading and therefore problematic. So let's hold on to answer choice C and evaluate D. D says yes, because the advertisements are not permitted under the rules of professional conduct. And D is wrong. Lawyers can advertise. They just have to conform to the rules. So that means the best answer to question 3 here is C.